Hello viewers, this is attorney Naresh Gehi, and today we are going to talk about deportation. Deportation is something that has been haunting a lot of people in this country, especially American citizens who are affected because their spouses or their children are getting deported. So today we are going to discuss how to avoid your deportation, or how to fight your deportation, or how to come out from deportation. So the question remains is that when people are in deportation, they think that they don't have any relief available in this country. Sometimes this may not be true. You may have relief available even if you have been ordered deported, or if you are in a deportation proceeding. There are many occasions wherein people unfortunately get into troubled waters. For example, they wind up before an immigration judge in this country, especially because the immigration documents are denied by the immigration officer. Now let's start this particular issue with an example. Your wife sponsored you for permanent residence in this country. She's an American citizen, and you were illegal, and your wife applied for your papers. After she applied for your documents, you went for the interview, and for some reason or the other, the immigration officer denied your case. For example, he denied your case because you came in without a visa to this country. He denied your case because you had a previous order of removal from this country, which you did not know about. He denied your case because you showed up at the interview and your wife failed to show up at the interview. So these are some of the reasons why immigration officers deny those cases. There are many other reasons. For example, you had a criminal record and the immigration officer said you cannot get your green card because of your criminal matter. What happens next? Thereafter, he will be referring your application before the immigration judge. If you lose on appeal, which means after you made your motion, and if your motion is denied, the immigration officer has the right to forward your case to an immigration judge. Very often people are very scared, they're petrified, and they think that they don't have any relief available in such instances. This is a big misnomer. We've had many people over the years who have been in deportations. We've also been able to help people come out from deportations. And there are times when people have also gotten their green cards when they have seen the immigration judge. So the question remains is, how do you handle your deportation matter? Firstly, always look at the charging document very closely. A charging document is known as an NTA, which is the notice to appear before an immigration judge. When you look at the notice to appear, you have to know what reliefs are available. For example, if you went for the interview, your wife did not go for the interview with you, and if you've been a victim of abuse, you can let the judge know that you want to file your case as an abuser spouse, because this is what your spouse wants. She wants you to get deported from the United States, and that may be an avenue which may be open to you. The second way for you to fight it is that, for example, you fear persecution in your home country because, for example, you're a gay, because you're a lesbian, or because of your membership in a social group, or because of your religion. If you think that you're a religious minority and you're going to be killed in your home country, then you have an option to claim a relief under Section 208 of the Immigration and Nationality Act, which means you may be eligible to apply for political asylum. You may be eligible to apply for withholding of removal, depending on the facts and circumstances of your case. You may be able to apply for CAT relief, which is commonly referred to as relief under the Convention Against Torture. Or you may be able to apply as a married spouse. There are reliefs available even when you're in deportation. A very common question which I get from a lot of viewers is, Mr. Gehi, what should I do when my relative is in detention? Which means, for example, I had a relative who came here and unfortunately he got into some troubled waters. He just had a few bottles of alcohol and he was driving. The cops pulled him over and they took him to criminal jail, and after that, now he's in immigration detention. Yes, that happens because your wonderful relative was illegal over here and he did not take care of his legal status. So what happened is that the criminal court issued a decision, he pled guilty, and you also paid your fine. You were very happy that he was going to be relieved. He was going to be released, but unfortunately, there's a big problem here. Immigration put out detainer, which means immigration came and they said that we want to take this guy in our custody, especially because he is not legal in this country. What should you do in this instance? Immediately hire a very good deportation lawyer. We've handled deportation cases from all over the United States. So what do we do in this instance? In this instance, when my law firm gets involved, the very first thing I do is we try to get the relative out on bond. Once if he's out on bond, at least your relative is happy, you are happy. Then after that, you can think about fighting the case depending on what reliefs are available. For example, your relative may be able to get married to an American citizen. That may be one relief. Or probably his parents might have filed for his documents before April 30th, 2001, and he's still legal, and he may be able to qualify under Section 245I. So, friends, what I'm trying to say is that even if you're in deportation, this does not mean that you cannot come out of deportation. There may be relief available to you. Recently, we met a client who had met quite a few lawyers, and they told him that he did not have any relief available. But after this client came to my law firm, I had a long conversation with him, and I found out that this particular gentleman, if he goes back to his home country, he'll be killed because he was persecuted in the past. We took up his case, and we fought his case before the immigration court in New York. And the good news is that this particular gentleman qualified for political asylum in this case. So remember, experience is a must, especially with the lawyer you're going to deal with. And if he is experienced in deportations, he may be able to help you. Remember, no lawyer can ever guarantee you any results, but it is very important for you to have good representation when you are in a deportation proceeding. Another very important issue that comes before me is that, Mr. Gay, I've been a green card holder in this country for many years, and unfortunately, I got involved with a drug-related offense, and I came here when I was only 2 years old, but I never became a citizen. But now the problem is that when I came back to this country, when I was traveling from abroad, the immigration officer stopped me and has asked me to report to him and see an immigration judge. What should I do? This is not good news for you, because this means a deportation proceeding has been commenced before you, against you, and you've been served with a notice to appear. Now you will have to fight this issue out, and if you fight, the good news is that you can still save your green card. The message to my viewers is that anytime, if you become a green card holder in this country, which means a permanent resident of the United States, it's very important for you to become a citizen in this country. The reason it is important for you to become a citizen is because if you are a citizen, you cannot be deported even if you're charged with a crime. So remember, anytime, if you have received a notice to appear before an immigration judge, or if you have a friend or relative who is in detention, come in and see us, and we'll be happy to help you. It doesn't matter even if you're in some other state. The best way to do it is to just send us an email or call us at 718-263-5999, and we would be happy to address your concerns. Now, there's something else which we are going to talk about. We're going to take a short break. Now, we're going to talk about something which is very important and that affects a lot of people in this country. Can you come out of your deportation, which means if you already have an order of deportation against you, which means we are dealing with an issue wherein a person has been ordered deported. How can you come out of your deportation, especially when you have an order which is outstanding against you? This means that you went before the immigration judge, or you have lost, or you never received the notice and you are ordered deported. Is there any relief available for those people? That is going to be the next part of our segment. Don't go away. We'll be back after a short break.
For all your legal matters including immigration, bankruptcy and credit card problems, divorce and family law, landlord and tenant matters, criminal and personal injury, call Gahey & Associates for a free initial personal consultation at 718-263-5999.
जब कोई बात बिगड़ जाए, जब कोई मुश्किल आ जाए, तब हम आपका साथ देंगे. Anytime you have a complex immigration matter, remember, मैं हूं ना. Hello viewers, so now we are going to discuss about options you may have if you have already been ordered deported from the United States. Sometimes I see a lot of people who tell me that Mr. Gahey, I already have an order of deportation against me. Can I have any form of relief available to me in this country at this point of time? Now we are dealing with a situation wherein a person already has a deportation order. What do you do in this case? Now this particular individual comes to me and tells me, Mr. Gahey, I swear to God, I never received the notice. And had I received the notice, I would have appeared in immigration court. But unfortunately, I moved my address and I moved from one place to another. And after that, I've just realized that the immigration judge has ordered me deported from the United States. Now, here I am in this country, married to this wonderful American citizen, and have 2 children from the relationship. What should I do in this instance? The very first thing you need to do is to just see a lawyer in person in this case, or just seek seasoned immigration advice, because this can be very important in your case. The reason this is important is because you mentioned that you never got notice of your deportation proceedings. Now, the good news for you is that if you did not receive the notice, and if we can prove this to the immigration judge, that you did not receive the notice, and for some reason or the other, and if the judge believes you, and if he thinks that what you're saying is bona fide after reviewing the record very carefully, then the good news for you is that your deportation can be reopened. Now, what does reopening means? Reopening means that the old case wherein an order of deportation was granted against you has been vacated, and you've been given a chance to come to court and explain what is your relief available today. Now, let's take the simple example which you mentioned earlier, wherein this woman, she's an American citizen, she's married to you, and she wants to sponsor you for a green card now. And now, you've been ordered deported. What the lawyer did for you, you filed for a motion to reopen. The case is reopened now. And after the case is reopened, now what happens? After the case is reopened, and if you came with a visa, or if you're grandfathered under Section 245I of the Immigration and Nationality Act, you can let the judge know that based upon the fact that you're married to an American citizen, you are eligible to adjust your status in the United States. The good news is that if this is your case, and if your case is reopened, then you can even get your green card in the United States. We've had instances wherein people had been ordered deported in the past. And what we did is that we had a very comprehensive review of the case. And after we reviewed the case, we agreed with the client that, this is what happened in your case, and immigration judges have reopened those cases. So remember that there may be light at the end of the tunnel. So it's always good for you to keep fighting your cases. And if you fight your case, you may be successful. If you're just going to sit and nap over your case, one day immigration may come to your doorstep, pick you up, and send you back to your home country. So always be extremely diligent in exercising your rights before immigration. Now let's take another example. You got your notice. And after you got your notice, you went before the judge. And after that, the judge ordered you deported. And now you were in receipt of the notice. What should you do? The law on the point is that if you want to reopen such cases, you have to show exceptional circumstances, which means that there were reasons which are far beyond your control. And because of those compelling reasons, you are unable to leave the country, which means that you could not leave the country. For example, you're married to this American citizen spouse, or you had parents over here who were extremely sick, who were green card holders, and they were on a deathbed, of course, those reasons can really help you to reopen your immigration case. Even if you have been ordered deported, or even if you've been here for more than 10 years, it doesn't matter. But the bottom line is that you have an avenue open if you can show exceptional circumstances. Exceptional circumstances means death of a relative that happened after a while, or serious health conditions. These are issues which judges look at very, very carefully in the reopening of those cases. Remember, judges are wonderful people, but they want to go by the law. They want to see that the law is properly applied in the case. And if you have a proper application, you may be able to reopen your deportation matter. Another way for you to reopen your deportation case is sometimes you can argue change country conditions. For example, country conditions in your home country have changed dramatically. Look at what's going on in the Middle East today, like in Jordan, in Egypt. If you think that you cannot go back over there and you'll be killed, and you're really, really, really going to witness a lot of horrifying issues if you go back to your country, then you can consider to even reopen your deportation case based upon changed country conditions. And those are possibilities for you to reopen your deportation matters. We have been successful in some of these cases. Remember, no lawyer can be successful in every single case, but it's always a good idea for you to get qualified representation and try to reopen your deportation matter. Deportation matters, even if they're in California, if they're in Georgia, we've handled cases from all over the United States. The issue is that if you have been ordered deported, I would recommend you to try to reopen your case, because if you get caught by immigration, you will be deported, and that's not a good thing, and that can even destroy your family in the United States. Sometimes I get people coming to my office who tell me, Mr. Gehi, something unfortunate happened with me. I said, what happened? The person said that I've been here for around 16 years now, and all of a sudden immigration came to my house and they want to pick me up, and they've given me a notice to appear before their office, and I've been here for 16 years and I have 3 children. One of them is an American citizen. The good news is that that can qualify you to come out on bond at least. So remember, there's nothing for you to be scared about. But my request to you is that anytime if a deportation officer calls you, the first thing you need to let the officer know is that you need time for a lawyer. It's important for you to exercise your rights diligently. If you have a lawyer, he will be able to protect you. Deportations can be very complex, and they can really, really, really have a chilling effect if your case is not properly handled. So remember, it's important for you to see that you properly exercise your rights, especially when in deportation. Sometimes I get a question from my viewers, Mr. Gehi, is it okay for me to accept an order of voluntary departure rather than accepting an order of deportation from an immigration judge? That's a very tricky question. It's a tricky question because, for example, you've never been illegal in this country, and if you have a clean record, I would prefer then you consider voluntary departure. But if you have unlawful presence in this country, and if you're going to take voluntary departure, and if you've been illegal for more than 1 year, you may be subject to the same 10-year bar. And it can haunt your case, because what happens is that once if you accept an order of voluntary departure, the bad news is that the judge does not have jurisdiction on your case for the next 10 years. So it may not be good for you to accept an order of voluntary departure. I had a question from a viewer who said, Mr. Gehi, my lawyer asked me to accept a voluntary or departure order and leave the country at the second hearing because he didn't have the file, he was not prepared. Be very careful. Let the lawyer know or the judge know that you want to get a second opinion on your case before you accept an order of voluntary departure. There's no harm in doing that, because once if you are accepting an order of voluntary departure, which means you may be cutting off a lot of avenues, and this can really haunt you. A very important question which I received from a viewer was, Mr. Gehi, I had accepted an order of voluntary departure more than 10 years ago. Now I have this American citizen wife and I have children. Can I reopen my case? Yes, you can try to get your case reopened by making a motion before the immigration judge. But the issue in this case would be that any motion to reopen has to be filed within 90 days under 8 CFR 1001. But if we can overcome that hurdle by asking the judge to either exercise sua sponte jurisdiction or by asking the judge that there are exceptional circumstances in this case can be reopened. So remember, keep trying if you have been ordered deported. If you are illegal, become legal in this country. If you are going to be legal in this country, the good news is that you'll be eligible for a lot of benefits. If you're illegal, you're living in fear every single day. You can be picked up by immigration. Nowadays, even if the cops are going to pick you up, you may be in the system and you may have a detainer from immigration. Is it worth the aggravation? A viewer asked me, Mr. Gehi, if I'm illegal here and I came in on a visitor's visa and I overstayed my visa, what should I do? The answer is very simple. Consider getting married to an American citizen. Getting married to an American citizen can have a lot of benefits. Recently, we handled a case wherein this gentleman was illegal for 32 years. He finally found an American citizen and he got married. And guess what? The person got the green card. It's not that difficult. But it requires a lot of determination from your end. It requires a lot of perseverance from your end that you want to become legal in this country. And if you have any further questions, this is Attorney Gehi, and we'd be glad to come up with some more segments to help our viewers so that they can understand the intricacies of immigration law. Immigration law is very complex, and always take care of your immigration matter at your earliest possible convenience. Most cases are denied because people don't take an interest in their case. They become illegal, they just don't worry about their immigration matter, and this can finally haunt you in future. So my recommendation is get legal, don't be illegal. If you are in deportation, try to get your relative at least out on bond and fight your immigration matter, your deportation matter, and fight for the green card. This is Attorney Gehi. We'll be back again with some more interesting news from the world of law.